Hi everyone, this is Natalia. I'm here live, just confirming that. We are streaming on several platforms, so allow me a couple of seconds here to connect to our account on Instagram as well. Hi everyone, Natalia is here today. Happy Friday. You probably are surprised a bit to see me today and not Ryan, because I know we announced that Ryan will be presenting today, but unfortunately Ryan got sick and I'm substituting today. I'll be happy to talk about immigration news, share some of the most important immigration news with you that we have so far for the month of October. So we do our first Fridays every first Friday of every month, and we alternate as attorneys. So right now, let's start with the most important immigration news. Okay, as we know, most of us know, we have US presidential elections happening next week, and our political parties are concentrated on the elections more than on, I would think, certain immigration updates. But nevertheless, we have some things to talk about. So I'm sure we will have more news after the elections, depending, how the elections goes, and we will talk about it potentially in December or in January. All right, let's talk about immigration news that we have so far. Okay, the new form I-131 was released by the USCIS, and this is big news because Form I-131 was not actually previously considered a lengthy form. It only contained 5 pages. As of now, it contains 14 pages. So it definitely grew in size. It is requiring us to fill out many pages, provide much more information that we had to provide previously. The form itself is already in use and it's effective. It was effective immediately. And if you're applying for a travel document, for a parole document, for any kind of advanced parole document, depending, on what kind of case you have, this is the form that you will need to file. So pay attention to the new edition of the form. It is very important because the USCIS will reject the prior editions of the form if you file, the form that consists of 5 pages. Then also pay attention that the form itself has several sections. So one important thing about this form is that it was designed for several documents that we are requesting from the USCIS. And there are certain parts of this form that pertain to certain kinds of documents, and they are not necessarily relevant to other kinds of documents. So be very, very specific and attentive in terms of filling out this form. Instructions were also updated, and you can find them on the USCIS's official website. If you have any questions about Form I-131, we have recorded a separate video about this form, talking about different sections of the form and what's the right way, to approach it. If you're requesting a travel document on behalf of somebody else, then there's a section that you would need to fill out with the information about that person you're requesting this travel document for. If you're applying for this travel document for yourself, then obviously there will be different sections that you would need to fill out. And don't forget to sign the form as well. Okay. Also, the USCIS rolls out a new online PDF filing process for select forms. Why I think this is a good news is because let's talk about Form I-912. This is a waiver of the USCIS's filing fees. Previously, if you wanted the USCIS to waive certain filing fees for certain forms, you had to file all the forms on paper. So you had to find a printing machine, like a printer, and print out the forms, then also print out that waiver form I-912. But right now, the news we received from the USCIS tell us that you can file that Form I-912 online when you're requesting Form I-765 application for employment authorization. So this PDF filing was specifically allowed for certain applicants who are filing an application for an employment authorization. To be eligible to file Form I-765 online, well, first of all, you would need to confirm that you fall under the eligible categories. So double check the USCIS's website in terms of the categories that are authorized now to file online. As an example of those categories, I can name category C8, that's the category for asylum applicants. Category C9, that's a specific category for employment application applicants who are filing based for employment authorization based on an application for adjustment of status. Also, certain TPS applicants will be able to file that form online and also file Form I-912 online directly through the portal. If you're wondering what kind of a portal that is, it is an online account that you may create on the USCIS's official website for yourself. So it's individual online account. If you already have this account, well, that's great. If you don't have this account, it takes about 5 minutes, maybe less, to set it up. And from now on, you can submit PDF application for an employment authorization document. There will be an option for you to choose to submit that specific PDF form, and you can also submit Form I-912 online, which is absolutely great news for a lot of applicants. Let's move to the next piece of news we have here. This is actually exciting. The DV lottery this year for 2026, it runs through November 7th, not through November 5th, as it was previously mentioned in the Federal Registry. So the Department of State has published officially a notice that the DV lottery is going to run until November 7th. 12 p.m. Eastern time, so New York time, right? There was a correction that was made in the Federal Registry that was published on October 1st of 2024. So that mistake was corrected. And for those of you who needed more time to register for the 2026 DV lottery, this is really good news. You have 2 more days to register for this lottery. Also, frequently asked questions that were published on the DOS's website were updated to reflect the correct dates. And you can take a look if you go to travel.state.gov and read about the correction of DV 2026 Federal Registry notice. So the government makes mistakes sometimes, but good to know that they are able to notice those mistakes and actually make corrections. That's great news. If you need any help with the DV lottery, please let us know. We here at Mackenzie, we have clients who applied or were selected for DV lottery, and have been successful helping those clients with their adjustment of status applications as well. Okay, next, I would like to talk about updates to the USCIS's policy in regard to the T visas. If you've never heard about the T non-immigrant status, then you should know that this status is reserved for victims of severe forms of trafficking in persons. So this so-called T visa is mentioned in the USCIS's policy manual, and that policy manual part related to the T visa has been updated. It has been updated actually to reflect that right now the USCIS is emphasizing a victim-centered and trauma-informed approach to adjusting applications for T non-immigrant status. It also explained the bona fide determination process for applicants for T status. It also revised the definition of the law enforcement agencies. So, to apply for T visa, like when you apply for T visa, you have to prove that you were in touch with the law enforcement agencies. So the definition of the agency has been updated. This is very similar to a requirement we have for U visas as well. This update to the policy manual also informs and provide clarification on any credible evidence provision to assist officers at the USCIS. Many other requirements were also clarified, and if you would like to read more about it, then the right volume is volume 3 of the USCIS's policy. So it talks about eligibility requirements for the T status, purpose and background. It also clarifies in terms of the eligibility requirements, requests for law enforcement assistance, and other items. So if you have more questions about this specific policy update, then the USCIS's website provides a pretty substantial resources in terms of the T status. And if you would like to read about this specific update, then the update and the policy alert was published on October 23rd of 2024. The Department of Homeland Security also confirmed that it offers protections for Lebanese nationals currently in the United States. So let's talk about this specific kinds of protection. Well, first of all, let's talk about TPS. It's a temporary protected status. The Lebanese nationals or people who last resided in Lebanon and don't have any other nationality will be eligible for TPS. It's a temporary protected status, and it has been announced that it will be provided to eligible applicants from Lebanon. So what it means that certain protection from deportation, from removal from the United States will be granted to those who qualify for a temporary protected status. If people qualify for a temporary protected status, they can also apply for a travel document based on TPS and for an employment authorization document based on TPS. I would monitor the USCIS's announcement in November in relation to TPS, just to make sure that you don't miss anything. Another update that was published is relating to the deferred enforcement departure for Lebanese nationals, and it provides information on how eligible individuals may apply for an employment authorization based on that deferred enforcement departure. So deferred enforcement departure is not an immigration status per se. It's more like a protection from deportation, that also from removal from the United States, that also allows people to file for an employment authorization. This is great news for the nationals of Lebanon who qualify for it. So this deferred action will be valid for 18 months through January 25th of 2026. It may be extended in the future, but we cannot guarantee that, as well as, the extension of TPS. Sometimes it gets extended and sometimes it just gets terminated. Also, certain F1 student relief was authorized by the Department of Homeland Security for certain Lebanese students who are present in the United States and go to school based on F1 visa. So F1 students are restricted in terms of the ability to work in the United States. So if you are a certain Lebanese national who qualifies for that student relief, you may be eligible to work more than 20 hours, and not only on campus, but outside of campus, if you qualify for that student relief. So please keep in mind that as well. All right, that's those were the news for the Lebanese nationals who are currently in the United States. In addition to that, let's also talk about how the embassy and the consulate in Beirut operates these days. So the United States continues to work to assist US citizens in Lebanon. It specifically stated that it will facilitate family reunification. So if a US citizen has relatives in Lebanon, then the Beirut consulate will continue working on the visas for those family members. If a person filed an immigrant petition, or if a company filed an immigrant petition for a person who is currently going through consular processing, then the update stated that the immigrant visas will still be processed in Lebanon, that the embassy will be helping people. If you would like to transfer your case from Beirut to some other consulate, then the DOS will understand that this request warrants specific attention, and more than likely they will assist you if you qualify for the case transfer. In relation to non-immigrant visas, so non-immigrant visa processing is not available in Beirut at this time, unfortunately. So if you have applied for a non-immigrant visa through this consulate, then make sure that you reapply through a different consulate, because this specific consulate is not going to process the visa request, the visa application. If you have not yet applied for a non-immigrant visa, but you would like to do that, then choose some other consulate that may be of help here. Those are not very good news in relation to the operations of the DOS in Lebanon, in Beirut specifically. Unfortunately, that happens. And if you would like to learn more about certain relief available to Lebanese nationals, specifically in the United States, here at McKinsey, we will be able to help. We have experience with TPS, with deferred action, with the employment authorization applications as well. All right, so the next update I have here is the one that relates to the International Entrepreneur Parole Threshold adjustments. So that again is about the updates to the USCIS policy manual. So what has been clarified here? So first of all, let's talk about the policy highlights. So this policy provides the revised amounts for the automatic adjustment of the investment, award, grant, and revenue thresholds. It also clarifies that USCIS generally coordinates with the US Department of State outside of the United States to arrange biometric appointments for conditionally approved applicants for this specific program who are currently outside of the United States and who elect to receive their parole documentation at the US Embassy or consulate outside of the United States. If you would like to read more about this update, then the right volume here is volume 3 and part G, chapter 1. That's where you can find updates in relation to this policy. Also, this policy alert was published on October 10th of 2024. And the specific number for this policy update is PA 2024-25. Okay, so these are all the news that I wanted to cover today. And let's take a look at the questions that we have. Okay, so we have received several questions here. I'll start with question number 1. Will the US Embassy in Ireland extend an L1 visa if you have a green card in process? It really depends on the case, but to answer this question in general terms, let me tell you that the L visa is a dual intent visa. So that means that an applicant who applies for an L visa is allowed to have both immigrant and non-immigrant intent. This is great news because what it basically means, it means that you can hold an L status while pursuing permanent residence in the United States. Sometimes when you apply for a non-immigrant visa that does not allow for dual intent, like for example in E-visa, right, an investment visa, E2 visa, the consulate may question you and probably will question you on your potential immigrant intent in the United States because you will not be allowed to have it. But generally for L visa applicants, dual intent is allowed. So generally, I would answer yes to that question, but please talk to your immigration attorney to see if you qualify, if you meet the requirements, and if you're eligible for an L visa. Next question is, how many times can I travel in 1 year on a visitor's visa? Great question. Actually, the regulations are silent on how many times you can use the visitor's visa to travel to the US in terms of a specific number. And the reason for it is that, your purpose to travel on a tourist visa should be tourism or business, right? In the United States, not employment, business. We have B1 or B2 visa for that purpose. Generally, you should not spend more time in the United States versus your time outside of the United States when you have the B visa. So let's say if you travel to the United States for 2 weeks on a B visa, then it would be reasonable to expect that you would spend more than 2 weeks, at least more than 2 weeks outside of the United States before you come back to the United States. If you have to be in the US, let's say for 2 weeks, and then leave for a week and then come back, generally you could be allowed to do that, but then you would be expected to spend some, lengthy time outside of the United States. So if you spend, let's say, during the 2 visits, you spend 3 weeks in the US, then you go back to your home country. I would suggest spending at least 3 weeks in your home country or even more before you get back to the United States. If you do those trips pretty frequently, then the CBP officers at the border will absolutely notice that. Maybe not the second, maybe not the third time you're doing that, but definitely if you do it, let's say 10 times or 20 times, the CBP officers may get concerned about your purpose of using this kind of a visa. They may place you in the secondary inspection, go through your luggage, go through your electronic devices to see if you have any other, immigrant intent, or maybe you're coming back to the United States to work. There, the CBP officers are always suspicious of that. They will ask you more questions the more you travel on that visa. And if those trips are so close in time, then the US CBP officers will more than likely ask you some additional questions and kind of, give you a hard time in terms of your travel. Okay, next question. Is having 2 kids together enough to prove a bona fide marriage? It's a great evidence to have their kids' birth certificates. So great if you have it. However, this might not be enough to prove a bona fide marriage. I know it may sound strange, but let me tell you about 3 kinds of evidence that the USCIS is looking to receive based on the regulations. So first of all, it's evidence of joint experiences. So having kids is, kind of an experience that you have together. So that would satisfy that prong. There is also a requirement to show joint finances. I know that the circumstances, in each family are different, and you may not have joint finances. Then maybe you have, joint insurance. Maybe you mentioned your spouse is a beneficiary on certain documents. That would also kind of, satisfy that requirement. Also, the USCIS is always, and the DOS is always looking to see documents of joint residency. So this is the third requirement. And sometimes we can satisfy two requirements, but not the third requirement. And sometimes we can, for example, have a lot of evidence of joint experiences, but not really a lot of evidence of financials kind of commingling finances. So in that case, we just try to emphasize the joint experiences the couple had, and that is usually more than having kids together. It would involve some photographs, maybe some, travel arrangements you made, proof that you celebrate holidays together, not just the birth certificates. So make sure to put more evidence in. You can be very creative with the evidence that you put in. Whenever we work with our clients, we send them a list of evidence items that they may have. And then, depending on what circumstances we have in a certain family, we just try to kind of be more creative and submit evidence that fits that specific family. Okay, another question I have here. Is there a way to transition to permanent residency as an F1 student? Okay, that's a great question. So F1 students may have both family and employment-based options. With the family options, it is clear. So if you have family in the United States, let's say a spouse, then the spouse can petition for you in the United States, and you can adjust your status potentially from F1 to that of a permanent resident. There are also employment immigration options that may be available to someone who is a student here. But that, requires some consultation, because we would need to find out what exactly you study in the United States, how long you've been a student here. So is it a master's program or is it a bachelor's degree? So if we are talking about EB3, then it's a multi-year, multi-stage process that involves obtaining a prevailing wage determination from the Department of Labor first, then performing a test of the labor market and applying for labor certification. And in addition to that EB3 process, we may also be able to discuss EB1 or EB2 processes. I wouldn't say that a lot of F1 students will be able to apply for those, but if you are considering applying for a green card, while you are an F1 student, then absolutely consult with an immigration attorney. Usually we have F1 students applying for an H1B. That's a more kind of, way more like regular way of how F1 students transition to the employment options. But if you have, a specific question about your specific case, then you would definitely need to consult with an immigration attorney. And the last question I have here is from Instagram. So let me read it. If you are from the UK and would like to get a visa for the US, I have family in the States. It is my granddad's side, but no immediate family live there. Will the family I do have help with my application? Okay, so if you don't have immediate family in the United States, then other family will be considered not an immediate family, but preference category, right? So if you're talking about grandparents, they are unfortunately not included in the preference category, but there are other relatives that are included in the preference category. So like brothers and sisters of US citizens, for example. So why we call them we call that the preference categories because a visa is not immediately available to those who are in the preference category. There are certain wait times associated with it, and the visa bulletin, which is published every month by the Department of State, kind of gives us an idea of what's the wait time. And you can take a look at the visa bulletin. It specifically describes the categories of relatives, and then it has a table that you can refer to kind of figure out how many years it would take for you to apply for an immigrant visa based on the preference category. And I understand you are talking here specifically about green card options. Sons and daughters of US citizens can also apply for an immigrant visa, and it's also a preference category because those are not children. Children are those who are under 21. Sons and daughters, those are who are over 21. Yeah, that's a great question. Also, if your parents were born in the US but then moved outside of the US, sometimes it's possible to obtain citizenship. So make sure you talk about it with an immigration attorney, because I know there are some people who were born in the United States, but at a certain age they just moved out to live, let's say, in Europe, and then never returned to the US, or returned to the US, lived here for a certain period of time, then moved to another country, had kids. So here we can also discuss an application for a certain immigration benefit. All right, so these are all the questions. I hope you found this webinar to be useful, and we'll see you next time. Enjoy the weekend, by the way. Here in Chicago, we have such a great weather. It's just very sunny, very nice here.